Civil procedure discovery rule scripts. Okay, first rule for discovery. Number 1, discovery must be relevant, non-privileged, and proportional. Proportional means how the importance to the parties in the case, the number of dollar amount at stake, the party's relative access to the information, and its burden versus the benefit. It's pretty easy to see whether something is proportional or not. Relevant, non-privileged, and proportional. Okay, let's talk about specific discovery limitations. Okay, we know that you get 10 depositions of a single person, you get 1 day of 7 hours, and non-parties only by subpoena. So anything in excess of that would not be proportional. In a deposition, what must you also do? When you give your notice of deposition, you must describe the matter to be disposed with reasonable particularity. Okay, proportional. A deposition, you get 10 deps of a single person, 7 hours over 1 day. You only get non-parties by what? That's right, subpoena. And you must describe the matters to be deposed with reasonable particularity. You must describe the matters to be deposed with reasonable particularity. Okay, interrogatories, 25 interrogatories, including the sub-interrogatories. That's our limit. That's proportional. How long do you have to answer interrogatories? 30 days. Requests to admit. Admit, deny, don't know. No limit on those, but only, that's right, parties can be served with a request to admit. What about our requests to produce? What do those involve? Again, this is only, I think it's only parties. Requests to test, copy, sample, or get entry to property. Requests to produce copies, samples, test something, or entry to property. Okay, now we have our mandatory disclosures. Remember, the mandatory disclosures are 14 days after the initial discovery conference. How long do you get for those mandatory disclosures? That's right, 14 days. What must you? There are 4 things that you must produce. The witnesses' names and their contact information. 2, documents and tangible things that the party will use to, that's right, support its claims and defenses. And our other 2, computations of damages and insurance agreements. What are our mandatory disclosures? 1, W for witness names and contact information. D for documents and tangible things the party will use to do what? That's right, support its claims and defenses. Computations of damages and insurance agreements. Why insurance agreements? Because those are used to compute how much money you're likely to get out of that lawsuit. Okay, so relevant, non-privileged, and proportional. Deps, 10 deps, single person, 1 day, 7 hours, non-parties by subpoena. Describe matters to be deposed with reasonable particularity. How long do you get to answer interrogatories? That's right, you get 30 days. Can you serve a request to admit on a non-party? No. Request to admit, only parties. And what does a request to produce cover? Copies of stuff, samples, tests, and entry to land or property. How long do you have for those mandatory disclosures? 14 days. After what? That's right, the initial discovery conference. And you must disclose the following 4 things. 1, that's right, the witness names and their contact information. 2, documents and tangible things the party will use to do what? That's right, support its claims and defenses. Computations of, that's right, damages and insurance agreements. There are 4 mandatory disclosures. The names, the documents, the damages, the insurance agreements. The names, the documents, the damages, the insurance agreements. Names, documents, damages, insurance agreements. 4 things, 14 days after the initial discovery conference. Okay, how long do you have to disclose the expert? You have to disclose the identity of the expert at least 90 days before trial. You're going to have to use expert testimony. You've got to give the other side 90 days. And of course, we need the expert's identity. We need 4 things: the identity of the expert, the subject matter about which the expert will testify, a summary of the expert's facts, and if the expert is going to testify, a signed report. Okay, expert testimony, we must disclose, that's right, 90 days before trial. And of course, we need the identity of the expert, the subject matter about which the expert will testify. Does the other side get to know the facts and opinions of the expert? Yes, we are going to provide them with what? That's right, a summary of the expert's facts and opinions. And if the expert will testify, the report must be signed. Okay, a non-testifying expert, you don't have to provide a report. That's just somebody that you hired to research your stuff for your case. We are only talking about testifying experts. Okay. For our non-testifying experts, can you subpoena them? No. You cannot compel discovery of the other side's expert testimony. Why not? Well, that's our next topic, work product. Testifying experts, expert reports, you have to disclose a summary, but you can't compel discovery. You give the other side a summary. You give them the subject matter about that which the expert will testify. You give them the identity. So basically, you're giving the other side 90 days before trial a capsule summary of what the expert will testify about. The other side cannot compel the discovery of your work product, which includes all the work that expert did for you. Okay, but actually, before we get into work product, let's talk about a motion to compel. Yes, of course, you can move to compel discovery, but not until you, that's right, certify that you attempted to confer in good faith. Motion to compel. You can try to do that. Maybe you'll succeed, but you definitely have to certify your attempt to confer in good faith. Okay. What about those physical and mental exams? Can you get those? Yes. If the party placed their, that's right, condition in controversy. And what do you need for a physical and mental exam of the other side? A court order and good cause. Can you get physical and mental exams of the other side's witnesses? Hell no. Only parties. Only parties. Okay, the condition of the person is in controversy. We're at a guardianship hearing or something of that nature. Then the other side can order a doctor to examine your client or witness. The other side can get a court order for a physical or mental exam with their own expert. Court order, good cause. That's our legal standard. Court order, good cause for those physical and mental exam. Okay, a protective order. What's a protective order? It's to protect something from discovery. Okay, why are we wanting to protect stuff from discovery? We're going to claim 3 things. 1, hey, it's outside the scope. 2, it's privileged. Or 3, it's an abuse of discovery. We want a protective order. We need to claim one of 3 things. A, outside the scope. B, privileged. And C, abuse of discovery process. Actually, that's an or. Protective orders, outside the scope, privileged, or abuse of discovery. Okay. You can seek discovery before starting the lawsuit, but only if the evidence would be destroyed or become unavailable. You can get discovery, via a deposition if the evidence would be destroyed or become unavailable. Okay, of course, normally discovery occurs after we have our initial discovery conference. All right, moving on to discovery sanctions. Discovery sanctions are different than Rule 11 sanctions in that they apply to parties and attorneys. Okay, so why do they apply to parties and attorneys? Because parties can also spoil evidence. Parties can also failure to comply with discovery. Okay, let's talk first about spoliation of evidence. You can be sanctioned if you do not preserve evidence. You, the party, and you, the attorney, can both be sanctioned because you have a duty to preserve evidence if you know, or you reasonably should know, the evidence would be relevant in litigation. Do not destroy those emails. There is a duty to preserve evidence and prevent spoliation of evidence if a party knows, or reasonably should know, the evidence would be relevant in litigation. Okay, what if it's ESI? Remember the emails, the hard drives? You have to organize it, label it, produce it in the form requested, or in some sort of reasonably useful form. ESI, organize it, label it, make it available in a form requested or in a reasonably useful form. Remember in the 90s, we had SciQuest drives? Nobody can use those anymore. So you have to produce that ESI in a reasonably useful form. Okay. Next, the dreaded adverse inference instruction. You, party, or you, attorney, fail in your duty to preserve evidence that you know or reasonably should know would be relevant in litigation. You can be sanctioned via an adverse inference instruction. If you don't preserve the evidence you knew, you reasonably should have known, it would be relevant in litigation, the court may sanction the party and the attorney. They can presume the information is unfavorable to your side. They can even dismiss the action or enter default. So you don't preserve evidence, your sanction is likely the adverse inference instruction, presuming the information is unfavorable to you, and then the court might even dismiss your lawsuit or enter default if it's bad enough. Okay, what if you, party, or you, Mr. Attorney, failure to comply with discovery? You can also be sanctioned. You can be held in contempt of court. Your failure to comply may treat that evidence as admitted. The court might strike your pleadings in whole or in part. They might stay the proceeding until you comply with discovery, and they might enter a dismissal or default. Okay, quickly, let's run through discovery sanctions. Discovery sanctions are against parties and attorneys, and let's get this down. Parties and attorneys have a duty to preserve evidence and prevent spoliation of evidence that they know or reasonably should know would be relevant in litigation. And this, if this isn't followed, it may result in an adverse inference instruction. Failure to comply with discovery, you can get contempt of court, your stuff can be treated as admitted, the court can strike pleadings, stay the proceeding, dismiss the action, or enter default. Okay, so let's talk attorney work product. We said relevant, non-privileged, and proportional. So let's talk about the non-privileged part. Attorney work product is privileged, but it may be discoverable if the other side demonstrates what? Substantial hardship, and inability to obtain it in any other way. 1, substantial hardship. 2, inability to obtain it in any other way, and that's Hickman. But what's absolutely protected? The mental impressions of the attorney. And just from our previous conversation, what else is protected? That's right, the expert testimony of the other side. And depositions are also protected unless there are absolutely exceptional circumstances. Okay, so our general rule of attorney work product is that it is privileged, but it may be discoverable if 1, substantial hardship, and 2, inability to obtain it any other way, but absolute protection for, that's right, mental impressions. What's also protected? The other side's expert testimony and their depositions, unless there are absolutely exceptional circumstances. And that's it for discovery and sanctions.